Hello and welcome to today's session as part of the virtual VCE Legal Studies event. My name's Jasmine and I'm the Schools Program Coordinator at the County Court, and I'll be moderating today's event. I see quite a few familiar faces, which is fantastic. I would like to begin by acknowledging the traditional owners of the land from which I'm speaking, the people of the Kulin Nation. All the attendees are asked if they can remain on mute, please. And if you have any questions, please use the chat function to message them through to me. Throughout the event, we will be asking for student participation. Students, I know it's Friday, but fingers crossed you're all very excited and willing to ask a few questions. I would invite the teachers to use the raise hand function and we'll select students to ask from there. We also ask if you can have your names set as your school. We also ask that you don't take any pictures or record the event. I will also ask for students and teachers that will be asking questions, if you can just either use a loud voice or if you could come up to the front of the classroom, it'll just help us be able to hear your questions. I would also like to thank the schools who sent through some fantastic questions. The judges will try and answer as many of them as possible. With that, I'm going to stop talking and I would like to introduce you all to the three panellists today. Judge Pillay, Judge Tran and Judge Clayton. Unfortunately, Judge Salamandris was unable to join us today. With that, I'll pass over to Judge Pillay for a brief introduction. Thanks, Judge.
Good morning to all the classes out there. My name is Judge Arushan Pillay. By way of brief background, I came into the law in 1996. I worked for about 6 years as a solicitor before going to the Victorian Bar and practicing as a barrister for 16 years. I was appointed to the County Court bench 2 years ago, and I practice mainly in the area of common law, though occasionally I dabble in crime. I'll hand over to Her Honour Judge Tran.
Thank you, Judge Pillay. My name is Judge Ann Tran. My 30-second history is I finished my law degree back in 1998, worked for all of about 2 years in a law firm before I went to the bar and became a barrister in 2002. From 2008 to 2015, I took a very extended period of maternity leave before coming back as a judicial registrar of the County Court in the commercial division. I've been a judge of the court in the common law division since October of last year.
My name's Judge Julie Clayton. I was only appointed in December of 2020, so I'm the newest judge on the panel, although I think I'm actually the oldest chronologically aged person. I worked with Judge Pillay, in fact, as a solicitor, but unlike him, I didn't go to the bar. I remained as a solicitor for about 20 years. And then I went to the Supreme Court of Victoria as a judicial registrar before my appointment to this court. So you can see that there are a number of different pathways that lead people to being judges in the courts in Victoria.
Thanks very much, judges. I will just encourage everyone, all the participants, to turn on your cameras. I can see about half a dozen people right now, but it'd be great if we can fill the screen with a few more people. Fantastic. I can see lots of cameras coming on now. I'm going to pass over to Judge Pillay and ask the first question, which is, how would you describe the common law and what is your favourite thing about the common law?
The common law is the way that we resolve civil disputes in Victoria and Australia. A civil dispute is really described best in its broadest form, which is a dispute between two people in our community that doesn't involve the criminal law. It can range from the smallest things like fencing disputes to major things where people accuse corporations of treating them unfairly or unreasonably and jeopardising their health. By that, I'm talking about cases which you might have heard of. such as asbestos cases where people in our community say that they've been exposed to asbestos dust and have contracted very serious diseases. I think for me, the key about the common law and why I think it's a wonderful system is because it allows people in our community to resolve disputes fairly and without the need to resort to violence. And that for me is something that's really, really important. My background is one where I come from a country where violence was often the way that disputes were resolved. And we have developed a system in Australia and throughout the common law world where we can resolve disputes without the need for violence, fighting, and aggression between people in our community. And that is something to be absolutely treasured. So I want you to think about the common law not just as a way that people can get to court and resolve things, but I want you to think about it as a way that our community deals with one of the fundamental problems that all communities have, which is how do you resolve issues that cause friction, that cause problems in our community without the need to resort to violence. So that's my favourite thing about the common law. Judge Tran?
Look, I wholeheartedly agree with everything you say, Judge Pillay. I come from that background of having worked in commercial disputes specifically. And so for me, what is offered in common law disputes as opposed to commercial disputes, which are also civil disputes, is that real focus on disputes between people that have a real impact on people's lives, talking about people who have been injured, who have suffered physical injuries, emotional injuries, who have perhaps in the workplace, perhaps in car accidents, had traumatic events and need some sort of compensation for that. So I think the justice that we're able to deliver provides not just the function of dispute resolution, but also the provision of compensation to people who really need that assistance. Judge Clayton.
Undoubtedly, my favourite thing about the common law is the stories. I think the common law is a microcosm of the society in which it exists. So you see the world walk through your courtroom. They're real stories, they're real people. Most of us, hopefully, touch wood, won't be the victim of a crime and won't commit a crime, but nearly all of us will have the sorts of issues in our lives that the common law deals with. We'll be injured at work, or we'll be involved in a car accident, or we'll inadvertently defame someone on social media, or we'll have a dispute with our siblings about an inheritance from granny, or we'll have a problem with a doctor that we think was negligent, or we'll be bullied at work or school, something like that. Or as Judge Pillay says, we'll have a dispute with our neighbour over the fence. These are the cases of the common law, and these are the sorts of things that we see in our courtroom. And the common law is really, as the name suggests, common. It's something that is common to everybody who lives in the society, and it's common because it does deal with the sorts of disputes that we see all the time. And it's also the area of the law that we see the values and the changing values of the society reflected back. So you can always have a kind of almost a snapshot in time of what is going on in society by looking at the sorts of cases that are issued in the common law jurisdiction. Whether that, for example, at the moment, you would see a great increase in claims arising from institutional abuse because of the focus that that's got in society at the moment, and the fact that we've had a big Royal Commission. You'll see in the list that I am in charge of, defamation, an increase in claims arising from social media, because we live in a social media age. So it's just, it's a fascinating little microcosm. It's a great snapshot. And I should say that if you have the opportunity to ever just go and sit in the back of a court, take that opportunity. It's better than theatre.
Thanks very much, judges. I might ask Judge Tran the next question, which is, how does the court achieve the principles of justice in the common law?
Well, that's a really big question, Jasmine. I think you need to start with what justice means and what the definition of justice means before you can even begin to answer that question. And it may be that for some people instinctively, justice means truth. But the reality that I think everybody is realising these days is everybody has a different truth. And it's very difficult to identify one truth that is absolutely correct. For us, practicing in civil as judges, truth actually means on the balance of probabilities, which means 51% says it's true, 49% says it's not true. Okay, so justice doesn't actually necessarily mean absolute truth. There are a whole lot of other factors that feed into how we deliver justice, and that has to include an acknowledgement that, for example, justice delayed is justice denied, and justice that costs more than anybody can reasonably afford is also justice denied, and justice that costs the public purse more than anybody can afford may also not be appropriate, because, for example, as much as we would like to see more judges appointed, more judges means less money for hospitals, less money for schools. So all of those factors have to feed into the question of how do we actually achieve justice at the end of the day. We as a court have some powerful tools to consider all of those considerations, one of which is something called the Civil Procedure Act, which was enacted in 2010. And that act says that in everything we do, leading up to our final decision, we need to seek to further the overarching purpose, which is to facilitate the just, efficient, timely and cost-effective resolution of the issues in dispute. So all of those factors have to feed into what is justice at the end of the day, not just truth.
Thanks very much, Judge. I might throw over to Judge Clayton now. What is the role of alternative dispute resolution in a civil matter? And is there an expectation that ADR has been exhausted before coming to trial?
When we talk about alternative dispute resolution, we're talking about ways in which the case can resolve without it going to a verdict by either a jury or by a judge. And there's a massive role for ADR in civil disputes. I think that almost every list would require some form of alternative dispute resolution to occur before the matter is allowed to go to trial. The reason for this is that litigation is really expensive. It's really stressful and it's really time consuming. And most of the time, if you can settle a case without it going to a verdict before a judge or a jury, it's better for everybody. Because you go into a case, you think you're going to win, but you might be wrong. You might lose. You might win, but you might not win as big as you hoped, and it might not really cover the costs that have been incurred in getting you there. So in the county court, we will almost invariably order that parties attend a mediation. And mediation is probably the most common form of alternative dispute resolution. There's lots and lots of people who are professional mediators, accredited mediators, or just people who are very experienced as mediators. And the role of the mediator is to be impartial and to see whether they can try and get the parties to resolve the matter. We also have at our disposal a tool called a judicial mediation, and that's where a judge or another judicial officer, like a judicial registrar, conducts the mediation in a court, either physically in a court or virtually in a court like this. And that can carry some powerful weight because the parties involved realise, well, look, we've actually got a judicial officer here. They're very experienced in this area and they're trying to help resolve it. And it can give it a little bit of a, I suppose, a sense of the seriousness of what's going to be involved if the matter goes further. There are other alternative dispute resolution mechanisms at the disposal of courts more generally. We don't tend to deploy them so much in the common law, but things like an arbitration or a non-binding arbitration where you might get a very early opinion almost from a judge or a judicial officer who will say, look, without having to hear all of the evidence, without you spending thousands and thousands of dollars preparing your cases, just on the facts before me, this is where I think it might head, or this is what I think might occur, and parties, it's almost, you could almost equate it to a kind of Judge Judy type scenario, where parties agree to go along and have that happen, and then either agree to be bound by it, or they might have a non-binding arbitration. So there are a lot of different mechanisms. The expectation is that parties will have done everything they can to settle a matter before they take up the resources of the court, before they incur the costs, and before they expose themselves to the stresses of that. We do sometimes get people who say, I don't want to mediate. I'm not interested in that. I want my day in court. Sometimes we'll listen to that and agree with them that there is no point in sending these people to mediation because they're just not going to be able to resolve it, and it's actually just going to impose an additional cost into the whole system. But most of the time we would either strongly encourage it or order it to happen.
Thanks, Judge. I'd just like to thank the students who have submitted questions in already, but also encourage those students and teachers who haven't submitted a question yet to place it in the chat or just raise your hand. So I might ask Judge Pillay, I might start with Judge Pillay on this question, and that's, how do those who are unable to afford representation in a civil case have proper access to justice? An example being, if a person is not eligible for legal aid. I'll pass over to you, Judge.
This goes to a point which Judge Tran raised, which is that when people come before the court, often the quality of their representation really affects the way that they present their case and the way that they are heard. And oftentimes that's half of doing justice in a case. It's hearing the arguments of both parties fairly. So sometimes where there's someone who has a lot of money, can buy lots of legal resources, they can present their case very well and they're heard very well. Contrast that with someone who has no legal representation, and you can really see that they're going to struggle to have their case heard properly. In Australia, we used to have a system where legal aid was provided for civil cases, but it's been quite a long time since that was the case. Now legal aid is reserved really for family law disputes and also criminal matters. So it leaves those people bringing cases, you've just heard about those workplace accidents or the transport accidents, those people bringing those cases do not have access to legal aid. And instead, what's been used to allow them to bring their cases to court and be heard properly is a system which we have in Victoria called no win, no fee. And that is where solicitors will take on a case and they won't ask for any payment up front. But if the case is successful, then they will take their fees after there has been a successful outcome for the particular person. So no win, no fee arrangements are one way in which people can bring their cases even though they have no money at the beginning. The other way that cases are brought before the court by people who don't have enough money is via what's called pro bono assistance. And pro bono assistance is simply barristers and solicitors acting free of charge to bring particular cases before the court. We've seen a rise in this court in the number of people who appear without any legal representation at all. And to assist those cases and those people to present their cases fairly, we've also seen a real rise in the number of solicitors and barristers willing to do pro bono work. And that's because the legal community understands that we all have a role to play in making sure that people's cases are brought before the courts fairly. So it's really those two systems, Jasmine, that operate to give assistance to those people who are unable to afford representation. No win, no fee, and also pro bono assistance.
Thanks very much, Judge. I might just add to the students who are sending through some fantastic questions. If you can add in the chat function if you are happy to go on camera or if you'd like me to ask it. With that, we do have a student, Jess, who would like to ask a question. So Jess, I will just ask if you can come off mute, thanks.
Oh, do I have to stand? What was the biggest impact COVID had on hearing cases?
I'll pass over to Judge Tran to answer that one, maybe.
All right. Thanks, Jess, and congratulations on asking the very first question. It's a great question. I think the biggest impact of COVID on the court has really been experienced in the criminal division, which has faced the extraordinary difficulty of not being able to run jury trials basically throughout last year. In the civil division, we were able to transition very rapidly to hearing trials completely remotely via Zoom. We weren't able to conduct jury trials, but we were able to continue to conduct trials where the judge heard the case and made the decision. So some cases were delayed as a result, but vast majority of the workload of the common law continued to be heard, really thanks to the very hard work of everybody involved from the court's perspective and also among the profession in getting used to a drastically different environment for hearing cases very quickly. Of course, that doesn't mean it hasn't impacted upon us. We are one court, so our resources need to now be put to a significant extent to the criminal division to assist them to get on top of the delays that have happened as a result of the COVID pandemic. And that places burdens on the judges who are hearing the civil cases. And there are cases that simply weren't capable of being heard via Zoom for a whole range of reasons. But I think from our perspective, the story of the common law division is actually one of successfully grappling with the challenges of COVID. Did you want to add to that, Judge Pillay or Judge Clayton?
I was just going to say that I think it was amazingly successful, and there were some positive sides to it in as much as the courts have for a number of years been trying to upgrade and join the 21st century as far as digital management of matters goes. And it would be fair to say that the profession were not always as open to that as they might have been. People who've been lawyers for a very long time get very used to doing things a certain way, and a lot of that was very paper-based. And the idea of having to transition to present all of your documents electronically, for example, was a big challenge. And certainly at the Supreme Court, we'd struggled with that, both with some judges and some members of the profession. But when the option is presented of get your case on electronically or don't get it on at all, suddenly sort of what might have taken 5 to 10 years was done in about 5 to 10 days. And everybody did transition. We did have some very amusing scenes where judges were sitting in their kitchens and dogs were barking, and there was one memorable moment where a particular member of the bar who operates out of a country property had a galah fly in through his open window and land on his wig. But these were understood as being one of the necessary things that happen in a global pandemic, and allowances were made.
Thanks very much.
Sorry, Jasmine, just one thing to add about that, which I had forgotten, but I think being able to do things remotely gave people outside the centre of Melbourne a great ability to participate in the court process. Oftentimes it's difficult for people who might live on the fringes of Melbourne or work in offices on the fringes of Melbourne, or even those small towns outside of Melbourne, to come into the court to do their court business. So they would often brief barristers. That creates a level of cost and distance for those people. but suddenly we started to see those people appearing on our screens, and they began to engage with the court a lot more. So I think it's great for the profession to have that engagement with the court, but that flexibility and ability to draw in people from the fringes of the city has been a real benefit as well. So I think that flexibility's been one of the real benefits.
Thanks very much. I might ask Judge Clayton this question. It's come through by an Emmanuel College student, and that's, do the judges have any other roles or duties when they're not hearing matters?
Oh, that's a really good question, actually. And the answer is yes, both within the court and often outside the court. So when you're not sitting in an actual trial, you're often writing a judgment, because in the civil jurisdiction, we frequently don't have juries. We do a lot of cases that are what we call judge alone. So you're often working on your judgments. Most judges in the common law division will manage a particular list, and a list is just a sort of specialised grouping of cases, and that means that you're dealing with the case management. So there are things that are going on behind the scenes all the time. There are often applications that are brought, there are often directions hearings, just keeping a track of the case and making sure that the parties are doing what they're meant to do to get the case ready. Apart from all of that, there are a number of different sorts of committees that the court has, and most judges will be involved in one or more of those committees, and they might range from things like the Rules Committee, which looks at the rules of court from time to time and updates them as we find deficiencies or ways that things might be done better, to most new committees, things like committees dealing with sexual harassment policies and diversity policies. So most judges will be involved in the management or that side of the court as well. And then judges also often have a public role to play. So it might be that they sit on some external organisation or are involved in an external organisation like Women Judges of Australia, or have a role to play in the Judicial College. So it's probably fair to say that most judges are reasonably involved beyond just sitting in court. They're involved in a number of other areas of judicial life or legal life.
We also sit on schools programs.
Yes, that's right.
That is very true. Thanks, judges. We do have a question from Manisha. If you would like to ask that one now, thank you.
Hi, I just wanted to ask, how do you prepare for each case?
Manisha, I think I heard that question.
Wait, did you hear? Sorry.
How do you prepare for the case? Is that right?
That was correct, Judge. It was, how do you prepare for each case? Just
assuming that it's a work cover claim or a Transport Accident Act claim, or even a medical law claim where someone alleges their doctor's done the wrong thing. Normally before the case starts, there are books of materials that each of the parties will put in, and they can run 100 to 200 pages each. So normally before the case starts, you've probably got a few hundred pages worth of material. Some of that material is about how the case is put. So the plaintiff has a document which sets out the way that the case is being brought and the allegations they make about why the defendant has done the wrong thing. So normally what you do is you start there, you read that document, you contrast it with the defendant's material, and then you get into the evidence about how they will prove each allegation. So normally before a case starts, I will try to read at least some of the books, if not most of it. And then once I've read that material, there'll be some things in there which I don't understand, or I think will be a really big point in the case. And most often I'll think, I just don't know enough about that point, and the barristers are going to come in and argue that point, and I won't be able to keep up. So what I'll do is I'll work that issue out, and I'll say to one of my associates, this is going to be a big issue in the case. Find me some case law on that and come and tell me what that's about. So my associates will do that, and then I'll have a discussion with them about that point. And in that way, I'll feel ready to go onto the bench and at least begin the case. So I would have read a lot, I would have worked out the major issues, and then I would have tried to at least have some idea about that major issue. What is the legal principle, or what's the legal principle going to be in terms of who's going to say what, who's going to argue which way. So those are the things that I try to do before I go into a case.
It is a little bit, in some ways, like preparing for an exam, except that you're also the person marking the exam. So it doesn't carry with it quite the same degree of stress, because you're not going to have to give the answer immediately, but you are going to have to work out what the questions are that you have and try and seek the answers. One of the things that happens in the common law is that we don't necessarily get a lot of notice about the cases that we might be hearing. The way that courts have to work in order to try and get through the numbers of cases that are brought is that they have to what we call overlist. So we list more cases than we have judges for. It's a bit like when you go to the airport and you get on a flight, but they've actually sold 200 tickets for a flight that only carries 100 people, and they bank on the fact that about 100 people each day will drop out. And we have a similar system in the courts, in as much as we might list 10 cases, but we know that 5 of them are probably going to settle, or 6 or 7 are going to settle. And we've only got 2 judges available. So we're hoping that, we'll whittle it down to those 2. It might mean that you get a case the night before. It might mean that you get a case on the morning, or it might be that you get a couple of days. So you really have to do as much preparation as you can in that limited time. But for example, this week I've had 4 cases. I've read 4 court books that Judge Pillay just described, and they've all settled. So I, in the end, didn't need to have read any of them, but each one of them will help me appreciate the sorts of issues that come before the court and hone my skills for the next one. So it's not wasted work.
Thanks very much, Judge. We have got quite a few questions coming through. I might ask the next question, which has come through from Wyndham Central College, and that's, how do judges arrive at the figure for damages in a civil case? Judge Tran, if you'd like to start us off.
That's a really good question. And it's really a process of considering all of the evidence that's been put before you by both of the parties, and then considering other similar cases and other similar awards, and trying to reach a figure that adequately compensates for the harm that you say has occurred. But it's a really difficult process, because the reality is someone's coming to the court and saying a wrong has happened to me, and as a result I have been injured. And we can't actually fix that. I mean, we can't actually make the injury better. All we can give is money. If you said to someone, would you take $50,000 to have your arm cut off? The answer is probably no. You wouldn't take any amount of money to have your arm cut off. But somehow we have to come up with a figure that represents the amount of compensation that should be received for an injury, even though the reality is that money is not true compensation for a physical injury that has happened to a person. Does anyone want to add anything to that?
Just going to add that there are also statutory limits, so that there are maximum amounts that can be awarded for certain types of damages. So for your pain and suffering, for a personal injury, the maximum that you can get is about $600,000. That doesn't take into account loss of earnings and other sorts of damages you can get, but just purely for your pain and suffering, it's about $600,000. And as Judge Tran said, you really wouldn't, given the option of losing an arm or having $600,000, I don't think there would be too many people who'd say, take my arm.
Thanks very much, Judge. I might bring up St. Peter's College, who have got a question now. St. Peter's?
Have you looked back on a verdict and thought you made a mistake?
I might pass that one over to Judge Pillay, thanks.
The short answer is yes. I lie awake most nights after giving judgment and wonder, if I could have written it better, if I could have reasoned better, if I should have read back and found more detail. And that happens almost invariably after every judgment. In the end, I think you, as Judge Clayton was talking about before, it's a bit like preparing for your exam in that you need to go through all the steps properly. So you need to listen during the evidence. You need to be on top of the issue so you can ask about those. You need to go back and read the material again and make sure you've understood what the witnesses are saying. And then you've got to pay attention during your writing. And ultimately, when you reach your decision, having gone through the process, you need to get to that point of thinking, I've done all the right things. This is the decision. It is my judgment about that. And so ultimately, you trust that you've arrived at the decision in exactly the right way. So that when you wake up at night and you think, I'm not sure if that was right, the thing that comforts you is that you go back over the process and you say to yourself, well, I did all those steps right. And it's like when you finish your exam that you're going to write in Year 12. When you get to the end of that exam and you put your pen down or your keyboard, you at least know, even though you don't know the result then, you know that you've done all that you possibly can to get the best mark that you possibly can at that point. And that is the thing that comforts me at night when I'm thinking about, have I made the right decision? It's that I've gone through the process. I've done exactly what justice requires of me in my particular role. So I'm sure others have different ways of approaching it, but for me, that's the way that I end up being comfortable with my judgments after I've handed them down.
I wholeheartedly agree with you, Judge Pillay. And I think it's a really important point to understand is yes, we're judges, but we're also human beings. And it's a really difficult job we do. And we don't actually guarantee a just result in the sense of, being able to ascertain the exact truth of the situation. We guarantee a just process. So we have a process that we follow. We have rules of evidence that we follow. And at the end of the day, we make a decision based on that process, based on those rules of evidence, which we think is the appropriate outcome of the case. And it may be that sometimes when we say on the balance of probabilities that we're satisfied that X has happened, that in fact the reality is that Y has happened. Now, that doesn't necessarily mean that we've made a mistake if we followed that process.
And if we have made a mistake, we'll get told that we've made a mistake by the Court of Appeal.
Yes.
So, and there's no doubt that sometimes we'll get it wrong and we'll get overturned on appeal. The important thing, I think, as a judge is to learn from that and to take that on board, look at what's been said by higher courts as to why our reasoning was flawed or the process was wrong, but not let it get to you in such a way that it stops you from being able to continue to make decisions in the future. Judge Tran said at the very outset, justice delayed is justice denied. And if we spend years agonising over every judgment, then nobody's going to get a result, and that's not going to be good for anybody. So even when you kind of get kicked, you've got to pick yourself back up and get on with the job and make the next decision. Full of self-doubt as we might be.
It's a terrific question, isn't it?
Thanks very much for that brilliant answer from all three of you. I'd just like to say to all the students, we're getting through some fantastic questions, and hopefully we'll be able to get through them all, but I'm not sure if we will. I might hand over to Bree from Kenai College in Gippsland, who has a question.
Could you please give us a brief description of the most interesting case that you've come across?
Now, before Bree sits down, can I just ask, is that a case that I've been involved in or that I've read about in the law?
Probably one that you've been involved in, please.
Well, can I tell you this story? And this is one of the reasons why I got into the law. It's because the law is about people. And as Judge Clayton says, the stories that those people tell you are sometimes heartbreaking, but because you can deal with people at times when they're in their greatest need, you can often do something positive to help them. And that is one of the great uplifting things about the law. So my case that I think about a lot, that is one of the things that I'm really proud of being involved in that case, because it was a great privilege for me. But it was for a family who had a young autistic child, and they really struggled with him. He occasionally was very disruptive, and they searched everywhere to try to find a good school to put him into that could accommodate his needs. And during this time, the parents went through some incredibly difficult moments in their relationship, in their business, and with their child, wondering if they were properly caring for him. They ultimately found a school to put him in, and they were overjoyed because it gave him a real outlet and it gave them some respite. And they're of course torn, because you want to do the best for your child. You don't want to push them away, but at the same time, you need your own life. Unfortunately, what happened at the school where that young boy was that during his breaks, he would wander around the school and he would pick paint off the school buildings and he would eat the paint. It was one of his habits as an autistic child. But the paint contained lead, and the lead began to affect his brain. And it affected his brain by exacerbating so many of his autistic traits. And he became incredibly violent at home. And he began to turn against his parents. And he would stay up all night and he'd just draw all over the walls. And his parents, who thought they were doing something so good for him by getting him into this school, were feeling the guilt that suddenly their child had turned and become someone who they were really struggling with. And it was only by the persistence of the parents in working out why he had changed that they were able to establish that it was the paint from the particular school and the effect that it was having on him. And being involved in that case and helping those parents with that discovery meant that not only could they take him out of the school, but they could remove the guilt from themselves, knowing that it wasn't them that had done this, that had caused this change to their child. And over time, watching that child go through a readjustment when he was moved from that environment, and they removed the lead from his system and they got their child back. That family fought for many years for that ultimate result, but it was just a tremendous thing to be involved with to help them through that process so that that family could have some harmony again. So that question just got me to talk about the favourite case that I've ever been involved in, but it still brings tears to my eyes when I think about that. So that's why I love the common law, and that's why I'd encourage you all to become lawyers.
Thanks, Judge. I might slightly diverge off of that track and ask Judge Tran, is there one case which has affected you particularly for whatever reason?
I don't know if I can top that. That's the problem. How do you follow that from Judge Pillay? I just wanted to add to what Judge Pillay said, really, which is something that I think perhaps even some lawyers forget from time to time, is that the law is actually a helping profession. It's a profession where we're there to provide a service to people, to help people resolve their legal disputes, get justice, whatever it might be. One case that I can recall that was significant for me and really reinforced that decision that I did want to work in the common law was a case involving a man who was at the age of, I think, about 45, living in a nursing home. He was schizophrenic, he was paraplegic, he was a former drug addict, he had hepatitis C, his life was pretty awful. And then he was hit by a car, and he was bringing an application to sue for damages for the injuries he'd suffered in that car accident. And basically what was being said against him was, you know what, your life was so awful before, you haven't been seriously injured as a result of this car accident. And the one thing that he was pointing to was to say, well, before I was actually able to wipe my bottom when I went to the toilet, and now I can't. And now I have to wear nappies, and that dignity has been taken away from me. I think, I did decide in that case that he had been seriously injured and that he was entitled to pursue his claim. But to me, I think that reinforced for me the importance of what we do and the significance of what we do for real people who need a voice.
Thanks very much, Judge Tran. I think we've probably got time for about 3 more questions. So we've got Yadani, who has been waiting ever so patiently to ask a question. So I might bring them up to ask the question now. Thanks.
Hello. How many extra hours do you have to do outside of your work?
Judge Clayton, would you like to answer that one?
Well, I suppose it depends what you mean by extra hours, because being a judge is not really a 9 to 5 job. We sit in court from 10:30 until 4:15. And so that sounds like a pretty short day. That's pretty good. If you just started at 10:30 and you finished at 4:15, you had a break for lunch, that's not very many hours. But of course, outside those hours, we're doing the sorts of things that we've already talked about. So we'll be preparing for the case, we'll be reading all of those documents, we'll be writing our judgments, we'll be sitting on committees. I actually think it's incredibly important that the work that you do does not consume your life to the point where you burn yourself out, you destroy your relationships, you destroy your family, and so on. And in fact, I was just talking about this with Judge Pillay the other day, and I think that Judge Tran would possibly agree with me that in some ways being a judge in terms of the hours is not as onerous as being a solicitor or a barrister, because we're probably, I guess, a little bit more experienced and can get through things a little bit more quickly than you can when you're first starting out. But also we're really mindful of the fact that we're in this for the long haul. We've got a lot of years ahead of us, and if we sort of are working 100 hours a week, then we're not going to find that sustainable. I try pretty hard not to take work home with me outside COVID hours. Of course, we're all working at home when it's COVID, but that means that sometimes I'll stay late at work. But I prefer, once I go home, for home to be the place where I'm spending time with my children and relaxing and doing those sorts of things. So it probably is very, very variable. You'll find people who do really, really long hours, and you'll find people who are able to be super efficient and get all their judgments done and all of their writing done and all of their preparation done within a couple of hours outside those court hours. You know, if you do go into the law, you probably are looking at a career that would expect you to be working more than 9 to 5. You know, it might be more like 9 to 7 or 8 to 6, or sometimes even longer than that. But I also do hope that that kind of idea that you go into the law and you're expected to essentially sign over your life to the firm that you're working for, I hope that those days are behind us. I hope that there's a better appreciation for your generation about the need for a work-life balance and the need to have really sort of sensible occupational health and safety rules around what's expected, especially of junior lawyers and junior members of the bar.
Much, Judge Clayton. I might get Judge Pillay to answer the next question, and that's, what happens if a party doesn't attend on the day?
Many things could happen, but it all depends on the circumstances. So if there's a real history that this person doesn't show up to court, then oftentimes we'll just strike out their case, which means we'll say, that's the end of the case. If you want to bring it, you'll have to go back to the start. But oftentimes there are real reasons why people don't attend. So if we've heard good reasons about that, then we might simply adjourn it, give them a chance to come back at another time. That sometimes comes with consequences, but really we're in the context about why someone hasn't appeared, especially if they're from one of the firms or they're a practitioner that we know has a lot of experience in the courts. It's really about the context, the reasons why they're not there.
Thanks, Judge Pillay. I might ask Judge Tran and Judge Clayton the next question, which is, what are some of the ways in which common law has created landmark decisions in Australian history and had a huge social impact?
Oh my goodness, where do we start? I think you could say that the common law has created all of the landmark decisions in Australian history. Not quite, but very many of them. Judge Pillay made a mention at the outset of, or perhaps it was you, Judge Tran, I can't remember now, of asbestos litigation. The changes that we see in terms of occupational health and safety have really, I would say, been driven by common law proceedings, forcing companies to pay enormous amounts of money for wrongs, for corporate wrongs, which then changes both practice and often changes legislation. The current kind of things that we're seeing, as I mentioned before, institutional liability. A lot of the legislative changes, I would say, were driven by the common law starting to make awards and starting to recognise the kind of harm that was done, and that being giving rise to a bit of a groundswell within the community, by society, and forcing that sort of change. When I first started out as a solicitor, there was a case on foot called Octedi, and it was a big case brought by a whole lot of Papua New Guinean landowners against BHP for contamination of their rivers and lakes because of a massive mine that BHP had in Papua New Guinea. They brought that case in the Supreme Court of Victoria. So even though it was all happening in Papua New Guinea, they had a link, which was that BHP's headquarters were in Australia, and they were able to establish that the case could be brought in Australian courts, and they brought it in Australia, and it ultimately settled, but very successfully for the landowners. And it just forced there to be an accountability where the government was unwilling or unable to provide the sorts of protections. The Papua New Guinean government was unable to provide the protections because it was wanting to encourage the mining company. There are just so many ways in which the common law really drives, or it's a bit of both. It reflects what's happening in society, but I think it has a real power to drive the kind of changes that need to be made at a legislative level. I could talk for hours on this, but I'm mindful of the time. I'll hand over to Judge Tran.
Thanks very much. I might slightly change the pace and ask Judge Tran a different question, and that's, what advice would you give to students who want to work in the law?
That's a good question to finish up on, isn't it, Jasmine? Look, the law is a wonderful profession. I am a firm believer that it's a terrific thing to study law, even if you don't ultimately want to be a lawyer, because it's basically civics education. Everyone needs to know how the legal system works and how the justice system works. And it's incredible what a range of possibilities there are out there to work in the law. You know, there's being a solicitor, there's being a barrister, but within those, there's the common law, there's commercial, there's criminal, there's working for a firm, there's working in pro bono. There's an incredible array of things that you can do. And yes, it requires hard work. There's no getting around that, I don't think. But it can be extraordinarily rewarding, and also it's worth just trying anything and seeing if it suits you. And if it doesn't, well, you've learned something there and you can try the next thing.
Thanks very much, Judge Tran. And Judge Pillay, do you have anything else you would like to add to that?
No, but I would just say, as Judge Clayton said, there are so many cases that have advanced Australia that come from the common law, and I can only mention Mabo and say that was a civil case, and that is part of how we're ultimately going to strive towards reconciliation in this case, in this country. So I just support everything that Judge Clayton's just said about the common law and its importance.
Fantastic. Well, on that, I think we might finish up. So a big thank you to our panellists, Judge Pillay, Judge Tran and Judge Clayton, for taking the time to participate in today's event. and for having some fantastic answers to some great questions. And thank you to all the students and teachers who attended this event and for all of your great questions. And thank you to the teachers who registered. Without you, we couldn't run these events. And if you haven't already, visit our website and check out our free educational resources. Students, this might help you with your upcoming assessments or exams. And we'll also be making the recording available next week. So watch out for that one. We'll also be sending out an email with a quick feedback survey. So with that, I would like to once again thank the judges and the students, and that will conclude this morning's event.